You would call the first case for this afternoon, please.
John Milton Arledge versus Darl Smith et al.
We'll hear from the appellant when you're ready.
My name's Keith Smart. I'm here on behalf of the appellant, John Milton Arledge. I would request to reserve 4 minutes of my time.
4 minutes? That'll be fine.
Your Honor, this case arose in Warren County in regard to a real estate transaction where the defendant, Robert Hadaway Trust, by its trustees, sold a piece of property to the defendant, Darl Smith. The history behind the transaction has bankruptcy issues. In the matter, Mr. Hadaway had filed a Chapter 12 bankruptcy converted to Chapter 7. My client, the appellant, filed a Chapter 12 bankruptcy also converted to Chapter 7. In the course of those bankruptcies, the bankruptcy court went back in time and voided some deeds that had been made from Mr. John Milton Arledge to himself as trustee of the Robert R. Hadaway Living Trust. Those deeds were voided for lack of consideration, and that property was divested from the recipient. At that time, it was the Robert R. Hadaway Living Trust, and vested in the bankruptcy estate of John Milton Arledge for administration at that point. There were other properties that were involved in other voidings of deeds and transfers in the bankruptcy court. The issue that we have here arose because at some point in time, the bankruptcies were completed. Mr. Arledge had a order that voided the deed from him to the trust, and he believed he was the owner of the property. Mr. Hadaway, who had also been discharged in bankruptcy, believed for whatever reason he was the owner of the property as trustee, and he proceeded to enter into a sale with Mr. Smith on property that was the subject of the avoidance. Mr. Hadaway at that time proceeded to modify a trust and used that modified trust in essence to provide a basis for his title to the property, which was sold to Mr. Smith. Now, we're here today based on a motion for summary judgment. And the motion for summary judgment awarded summary judgment to Mr. Smith as the first order from the bankruptcy court divesting title from the Robert R. Hadaway Living Trust was not recorded in the Register of Deeds office as a standalone document. There was a second order that involved other property that was actually recorded as a standalone document. That document referred back to the preceding bankruptcy court order and noted that those properties under the preceding bankruptcy court order had their conveyances declared null and void. Now, in the course of the transaction between Mr. Hadaway and Mr. Smith. Mr. Smith had a title search done, and the title search came back, and based upon the testimony of the title attorney, the title search revealed no orders or liens on the particular property at issue, except the attorney noted there was a bankruptcy order down in relation to what was stated as an unrelated piece of property. That unrelated piece of property was other property conveyed by Mr. Arledge to the trust, which were all involved in the reversal of those transactions in the bankruptcy court.
Counsel,
Yes.
the mystery to me in this case is what was the purpose behind voiding the deed? Typically, Chapter 7 trustees don't void transactions by the debtor to benefit the debtor. They do it to benefit the debtor's estate so that there are assets to distribute to creditors. But as I understand your theory here, your client believes that this whole thing was set aside so that he could retain title.
Not necessarily. It was set aside for the estate, his
Okay.
bankruptcy estate.
So what did
Along
the
with other
estate,
properties.
what did the estate do with that property then?
The estate had that property and several other properties. The other properties were auctioned and sold, an auction at which Mr. Smith attended. And those properties realized enough total proceeds to pay off and pay out the claims against Mr. Arledge. In his
So
case, so
You
his
had, so
property,
this was a 100% case.
yes, it was a 100% case.
And so is there some order in the record somewhere where the trustee abandoned the estate's interest in this piece of real estate? I mean, it had to be administered in some way.
It was administered in the sense that there was an adversary proceeding that nullified the transaction, brought
So,
it back in.
right, so
to the
that's step
debtor's estate.
one, but then the estate has to do, then it's in the estate. It's not Mr. Aldridge's real property, it is the estate's real
Well,
property.
it is, and generally upon the conclusion of a bankruptcy, the property that remains in the debtor's estate is abandoned, and in this case, it was.
So is that
although
order in the
That order
record
is
so that
not
we
in-
can trace how your client got its interest? I mean, to me, that's sort of crucial here, is it not? Because if you're saying there should have been some sort of inquiry notice to look behind the transactions, you know, the inquiry for me would go, well, it's in the bankruptcy estate, I need to look somewhere there, but I don't see in this record any evidence of what happened to this realty. You're saying it was ultimately administered and surrendered by the trustee, but I don't know that from this record.
The answer filed by Mr. Hadaway indicated in the documents provided with that a copy of the administration, including the discharge and the
So
various.
was that filed in response to the motion for summary judgment here?
That was filed originally as a part of his answer to the complaint,
Okay.
and so those records were.
So that really
early on.
didn't factor into the court's decision-making here one way or the other?
I don't believe it did.
Okay.
I believe the court's decision-making was looking at the question of what actually Mr. Smith would have known or have perceived over the course of the transactions leading up to the sale.
And so this
And-
began, Mr. Aldridge and Mr. Hadaway's bankruptcies both began as Chapter 12, so they're both farm bankruptcies,
Farm bankruptcies,
ultimately converted to sevens.
correct.
Same trustee in both cases?
No, Trudy Edwards in Mr. Arledge's case and Terry Gregory in Mr. Hadaway's case. And in the bankruptcy, although it's not in the record, there were a number of cross motions and actions to try to seize it for one or the other estate. But as we get to the matter at hand with Mr. Smith, he had quite a history in dealing with Mr. Hadaway and Mr. Arledge. They're all farmers in a small community, did business back and forth as noted in the statement of facts. And he attended the bankruptcy sale. He saw that the property that we are dealing with right here was originally advertised for sale as a part of one of the bankruptcy estates, but pulled from the sale. And that was apparently because of the other property having sold for enough to clear it.
Well, there was no proof as to why it was pulled, though, was it?
There's nothing in the record on why it was pulled,
Okay.
other than the conclusion of the case with the other property being sold and having paid off the debts.
We don't do too well assuming.
I know, we don't. We have problems assuming. But the question is, what would have put Mr. Smith on notice that there was something going on? And
And is that the real question that you're
It is.
here is whether or not he should have been either on actual notice, are you saying, or just on constructive notice?
Well, the
Or
question
both.
on constructive notice would be whether the second order that was recorded, divesting title on the other properties that his attorney found in the title search, was sufficient. It did not identify the property, the specific property, but it identified other transactions between the parties to the current deed between Mr. Arledge and between Mr. Hadaway's trust, and set them aside with the language that they were all null and void. I won't say all, they were null and void for lack of consideration. And so I would argue that looking at that as an attorney searching a title, you'd want to investigate further. Considering that Mr. Smith had knowledge of the bankruptcy, had knowledge of the auction, had prior property purchased from one or the other, which had been repossessed from his barn. He had credit relationship with one or both of them, and had been doing business off and on over an 8 to 10 year time period with them. And he had enough background information to where we would expect. He knew about the bankruptcy, he knew about the sale, he had questions in his mind that he could have asked, even though it was several years before this transaction.
And there were two separate orders here setting aside transactions. Did those come out of separate adversary proceedings, or was it a single adversary proceeding, or was it just agreed orders?
A single adversary proceeding by the trustee of Mr. Arledge's bankruptcy estate versus Mr. Hadaway, the Hadaway Living Trust, and involved the Robert Hadaway bankruptcy estate trustee. So they were all of the interested parties in the bankruptcy case were involved.
I see. So what bankruptcy did the adversary proceedings originate out of? Was it just one of the bankruptcy cases or both of them?
It originated out of Mr. Arledge's separate case.
Okay, but a single adversary proceeding that ended up resulting in two separate orders.
Correct.
Avoiding real estate transactions. Okay.
Right, and the orders reflect the sequence of events and why it occurred, but in essence, the pleadings were not ready for a judgment against Mr. Hadaway on a separate piece of property. There was a default judgment granted for the property that issue here, but a separate piece of property had to have some amended pleadings and be brought in for a sale, for a order voiding that particular deed. And that's why as I understand, why there were two separate orders. It was the same case, but one was ready for a judgment by default, and the other required additional pleadings. So it's a case of small town where everybody knows what everybody's business is. And unfortunately, in this case, when Mr. Smith went to purchase the property, he didn't apparently inform his attorney of some of the other things that he was aware of that would have allowed both of them to put their heads together and realize there is a problem here.
You have your time for rebuttal, counsel. You've used your time. You have your time for rebuttal.
I'm sorry, I'm out of.
That's all right. We'll hear from the appellee.
Good afternoon, and may it please the court. Dylan Reeves for the appellee Darl Smith. I'm standing here like much of you. This is a case about what's not in the record. There's a lot of context that we just heard. It's not in the record. And that's kind of the position that Mr. Smith is in. He's someone, he goes out and he purchases a property. Like most bona fide purchasers, he did not have notice. The reason he didn't have notice is the bankruptcy order at issue was not recorded. Tennessee law is well established that the order is only effective against non-parties to the case if it's recorded. You get an inquiry notice, which seems to be the big question here. Well, we need to look at it the reasonable person standard, not the reasonable attorney standard. It's not a question of what did the title attorney do. It's a question of what did Mr. Smith do. Mr. Smith did what a very prudent person would do, and he went and hired an attorney to search title. That title attorney, and this isn't the evidence, there's an affidavit from the attorney over what the industry standard title search is, and it's the only evidence in the record. The industry standard is you start with a current owner and you work your way back 30 years. When you go back, you work your way forward. And anything you find in that search is your reasonable title search. So to any extent that Mr. Smith had inquiry notice, he satisfied that inquiry by doing what a reasonable person would do, hiring an attorney. He relied on his attorney's advice, and that makes him a bona fide purchaser here. And we think that's very important because it satisfies, if you ever get to it, if you ever get outside of actual notice, he does not have actual notice. He was not a party to the bankruptcy. You have this separate order floating around that is in the chain of the title. Again, what would a reasonable person do? A reasonable person hired the attorney. The attorney looks at it and says, it doesn't pertain to this property. It's a bankruptcy order, but it relates to an entirely different parcel of property. If they knew to record an order, if it pertained to this property, then certainly they'd have recorded an order that pertains to this property. What we do have floating out there, much like a wild deed, is the order that does pertain to this property. Unfortunately, the order that pertains to the property is attached as an exhibit, and I want to make that clear. It's not like it was given on a stack of papers to the local clerk who somehow misrecorded it. It was intentionally an exhibit to a deed to another unrelated piece of property. It's floating out there. It was not intentionally recorded in the chain of title.
Is that the first order or the second one? There were two orders, right?
I believe it is the first order.
All right.
And Your Honor, I'm suffering from the same problem here. There's not a developed record, and I'm constraining myself to what's in the record. But from what I see in the record, the second order, the argument is there's inquiry because if you would have gone back and traced the case somehow, you might have found another order that wasn't properly recorded. So again,
The second order still didn't apply, or did it apply to this property?
the second order, and I'll accept that it's the second order,
Yeah.
it did not pertain to this property.
Okay, so
It
neither
showed up in
neither of those two orders pertain to this property in question here.
The first order pertained to the property, but it was attached as an exhibit to a deed that did not pertain to the property or the parties to this
All right,
transaction.
I understand.
So if you took a deed between John Doe and Jane Smith and you attached an order to it as an exhibit, just completely unrelated, that's why it did not show up in the title search, because it wasn't indexed. It was on a completely unrelated deed. And then what did show in the title search was a bankruptcy order that did not pertain to this property.
So, but does that second order make any reference to any prior orders in the adversary proceeding?
I believe it refers to a complaint. I think it's got a docket number, a docket 39. But again, it didn't pertain to the property. It's clear that it's an unrelated piece of property. And so what would a reasonable person do? Not a reasonable attorney. A reasonable person has hired a attorney to search title who's assuming that if there's a bankruptcy order out there that's related to this property, they'd record it, especially if they've recorded this other order that's unrelated. Someone was savvy enough to know I need to record an order for it to be effective. And that's an assumption that underlies Tennessee's entire race notice recording system. If it's important enough to record it, you better. If not, there are consequences. And we discuss in our brief that Tennessee law is not forgiving to people that don't protect their own interest. And Mr. Arledge did not protect his own interest here. However, on the other hand, Mr. Smith did protect his interest. He hired an attorney, which is a big step for an ordinary person buying an ordinary piece of property. What more can you expect of a person, a reasonable person? And unfortunately, that's all the evidence there is in the record. We don't really have much else to go on other than speculation. You know, sure, I guess hindsight's 20/20. You can find something someone always could have done, but in the reasonable person standard, the only evidence here is that Mr. Smith did what a reasonable person would do, and he hired an attorney. And unless the court has any other questions, I will yield my time.
I hear none.
Okay, thank you.
Thank you. We'll hear from the appellant in rebuttal.
I would like to address the question which Judge McBrayer asked. The order, the second order, did directly refer to the prior order noted as document 39 and indicated that by the consent of the parties to this second order, which included the consent of the trustee acting for the Robert R. Hadaway Living Trust, that the conveyances in this order and those in the prior order were declared null and void, and the prior order would be amended to reflect those conveyances. And with that, that is the connection between the two orders.
And so, as I understand your argument then is that of the recorded order, that language should have directed counsel to look at the prior order because it incorporated some of the terms of the initial order, at least amended the middle list order, and so you would go back and look at that.
Sure,
Okay.
That's correct. And that's what I believe is the connecting point between the two that would put someone on some type of inquiry notice. If it had just described the book and page number of the transaction, it would have probably been sufficient on its own to have been constructive notice of the voiding of that particular transaction. But it just referred to the parties, however many conveyances they may have had at that time. All of these, anyway, that's it.
Okay.
Thank
Of course, thanks to counsel for both sides. We appreciate your arguments here in your brief. I think the issue before us is